Welcome everyone. Today is the fifth webinar in the 2021 MSHA webinar series from Conmonte Carey. We will be discussing an MSHA mid-year update and Federal Mine Safety and Health Review Commission update and case review. I am your host today, Nick Scala, as always. So welcome back to those of you who have joined us before, and welcome to anyone new. So I am the chair of Conmonte Carey's National MSHA Practice Group. We support companies all around the country in all aspects of dealing with MSHA, really. We represent mine operators and independent contractors in litigation and compliance assistance, help you with the commission litigation before the Federal Mine Safety and Health Review Commission, and also work with you all through investigations, whether that's for serious injuries or fatalities, and hopefully that's never the case, or for special investigations into agents of management or for whistleblower and discrimination claims. So really we're here to be a resource for you in all aspects of dealing with the Mine Safety and Health Administration and its enforcement arms. So what are we going to cover today? So, you know, we're at the mid-year. We do this one every year just to kind of get the temperature of what we've seen since the beginning of the year, and when we do our end of year or beginning of the year roundup. Given that this is a first year of a new administration, we'll have a little bit more to talk about and also a little bit less, because we still have quite a few unknowns going on with different areas at MSHA. One of those is going to be leadership. We have some news to report, but not some of the big news that I think people were hoping for. We'll also took a look at some of the earlier data that's now published from the last year, from the last full year, 2020, as well as some ongoing trends, initiatives, and rulemaking that MSHA has in the pipeline right now. Then we'll just take a bit of time and check up on the Federal Mine Safety and Health Review Commission. For those of you who know, that is the agency or the body before which we litigate, and they are our first stop with MSHA matters and MSHA litigation. And so we'll also talk about a couple of decisions that came, one from them and then one that came down from the federal courts, where we would go beyond the commission that might impact you guys on a regular basis. So to get started, what's happening with the MSHA leadership? As you guys all know, we had a presidential election last year. There was a new administration elected. With that, you see the departure of the presidential nominees. That was no different with MSHA this year, where David Vitezolo, along with several of his appointee deputies, vacated the agency. So right now, we are still waiting to see who's going to be the new Assistant Secretary of MSHA. Not even that we're waiting for a name we know to be confirmed through the Senate right now. We don't even have a nominee. And it's actually been pretty quiet on that front. There's not a lot of rumblings about who that might be. On the OSHA side, there is a nominee. That is Doug Parker. He was formerly the head of Cal OSHA the last couple of years. And prior to that, he did spend some time with MSHA during the Obama administration. There was some talk and some thought that he might be the MSHA nominee, but he actually got the nod for OSHA. So he has not been confirmed by the full Senate yet, but he has made it through the Health Committee. MSHA still doesn't have that Assistant Secretary nominee, though. So what that really means is we have MSHA being run by you know, some of the career folks who have been there and are obviously going to stay there through the administrations for the most part. And then also we have an acting head of MSHA whose name is Jeanette Galanis. Jeanette was previously the chief of staff at one point in time during the Obama administration for then Assistant Secretary Joe Main. She's got ties and previous experience working with the AFI-CIO. She's now going to be technically the Deputy Assistant Secretary of Labor for Policy at MSHA, but right now she is just the Deputy Assistant and effectively the acting head of MSHA. So, you know, what does that really tell us? You know, a couple of the names I just mentioned, you know, we're talking about Doug Parker over now the nominee to lead OSHA. He was getting talk about coming over to MSHA, and now with Jeanette as the acting head of MSHA for the time being, we see that the Biden administration is drawing on personnel that have previous experience with the Obama administration. That should tell us a bit about where we're going to see the policy and the attitude of MSHA moving forward. I think we're already starting to see some shift back to that more aggressive stance with the Obama administration. And, later we're going to look at some of the enforcement data, including 2020. And I think there's some pretty marked enforcement trends, or at least enforcement data, that will show some deviation. I think that 2021 might be a bigger year in terms of enforcement than we've seen the last few. Also, in terms of leadership, Pat Sylvia is still there. Pat has been the Deputy Assistant Secretary for Ops since 2010. She's been with MSHA for a very long time. She is a career deputy. She is pretty constant. You've probably heard her on the stakeholder calls if you participated, or seen her at some of the programs where MSHA sends senior leadership to speak. So she is still there. She has been there through multiple administrations, and she is really the constant in terms of the deputy side. So she'll continue to have a big role in management, but she is still there, meaning the carryover from normal operations continues. On the enforcement side, there has been a bit of shuffling on the administrator for enforcement. So previously, before the One MSHA initiative, we had an administrator for coal enforcement and an administrator for metal, non-metal enforcement. As part of the One MSHA initiative, Tim Watkins was named the administrator of both coal and metal, non-metal enforcement during the last administration. Tim is now going to be the deputy administrator of enforcement below Nancy Rooney. Nancy is relatively new to MSHA, from my understanding. She was previously with another division in the DOL, and she will be over top of enforcement moving forward. This is a pretty new development just in the last month. There was a time that Sam Pierce was listed as the acting director or acting administrator for enforcement. He is going to be stepping down and retiring, is what we understand. He's still listed right now as the regional manager for the Eastern region of MSHA. But what we've heard is that he is going to be retiring, which means there could be a little bit more shuffle on that end as well. But in addition, we're going to get a new administrator. Now, Tim was a pretty much career guy with MSHA. He's got a lot of experience in the mining industry. So from what we understand, Nancy's going to play a much bigger role in terms of management rather than specifically dictating policy. But it's a bit of a unique change. Historically, the administrator for enforcement has been someone that has kind of climbed the ranks with MSHA, more so than someone coming over that with a larger focus on organization and management. So that's going to be something to be interesting. And that could be part of the fact that MSHA has consolidated all the coal and metal, non-metal enforcement personnel and resources under one person. So they think that they are trying to get someone with a bit more experience on handling that kind of magnitude of management. But nonetheless, we'll see how that develops and just what that might lead to in terms of a focus with the agency. You've heard me mention it now a number of times, and you probably heard it more than you wanted to over the last couple of years, but what's happening with One MSHA? So as I mentioned, One MSHA was a significant shift in organizational structure of the agency during the Trump administration, and championed by then Assistant Secretary David Zeteslow. So what this did was essentially move the agency from a two-division, metal, non-metal, and coal kind of setup to one, as we talked about with the selection of a single administrator. What we saw then was MSHA divided the country up into 3 regions, which are the map on the screen. They put regional managers in each one of those who were effectively management above the district level. So historically, to get in contact with someone above a district manager level, you had to go to Arlington. The regional managers changed that. Now, it hasn't been formally rescinded or changed. Jeanette Galanis, who's now the acting head of MSHA, the deputy assistant, says that they're going to continue to give the program time to succeed and a chance to succeed. I would not, though, imagine we won't see changes to it here in the near future. And I think we're already starting to. As I mentioned, Sam Pierce was shifted to Arlington, or at least a more Arlington focus as acting director or acting administrator of enforcement for a bit. And as we heard, he might be retiring or moving towards retirement this month. So that would mean that the East region needs a new regional manager. Now, whether or not one is assigned quickly or if maybe they just let that kind of wither on the vine, we'll wait and see. Brian Geppert is also someone who was a deputy administrator in Arlington during the beginning of the Trump administration, and then he was granted the regional manager position in the West. He currently is listed, as is Sam, in their regional manager roles, but Brian is also listed as the acting director of education and training resources for MSHA. So, are we going to see again, maybe him vacating that regional manager position and focusing more on that other role that he's now listed as acting? We just don't know that right now, but I think it's interesting that, 8 months in to, or 7 months into the new administration, really, we're seeing, 2 of the 3 regional managers potentially changing. David Weaver is still the head of the Central, or the regional manager of the Central, but we haven't heard anything really changing on that front. But who's to say that it couldn't? So that's a bit of an interesting kind of dynamic as we see this One MSHA initiative that got a lot of focus and a lot of attention during the last administration. Now, kind of, is that going to be continued? I don't think we're going to see an immediate change back to a complete division of metal, non-metal, and coal. I think there's probably a lot of resources put into merging that and training up crossover inspectors in the areas where those are prevalent, which is really through kind of the Ohio River Valley area over into the Midwest. That's where we've seen the most, really, where you've had a big reduction in the amount of coal mining operations, and therefore you don't need all the coal mining inspectors. That's the area where you see the majority of the crossover happening. And I don't think we'll see that change. Now, will we see some realignment of field offices so that historically metal, non-metal field offices begin to retain some of those mines that were shifted over to coal? I think that would be nice for those metal, non-metal operations that were shifted, but we've heard nothing to say that that is going to be something that imminently happens. So right now, the changes in management, the changes in kind of redrawing the lines of MSHA jurisdiction for field offices and districts, that's going to remain in place. But this is something to watch, especially as we start to lose the leadership. Who's going to be replacing them? Are they going to be replaced? Could we just get rid of the regional model but still have the transfer of the other areas and other jurisdictional lines? That's entirely possible. So we'll have to watch what happens with One MSHA. But again, given the lack of a formal assistant secretary in place, a lot of this is going to wait until that person gets nominated and confirmed. I think when we dealt with the Trump administration, Assistant Secretary Teselo was confirmed in November of 17 after the 16 election, but he was nominated well before where we are now. And the way that we're really dragging on the confirmation process, especially looking at a sister agency in OSHA, I don't think it's really unfair to say we probably won't see an assistant secretary in place by MSHA by the end of this year. OSHA hasn't had an assistant secretary since a confirmed assistant secretary since David Michaels left at the end of the Obama administration. So really an interesting kind of dynamic going on in Washington, where leadership or confirmed leadership at these agencies is kind of a difficult thing to come by. So that really does affect and shape a lot of the policies. At OSHA, during the Trump administration, we really didn't see the drop off in the enforcement and maybe the shift in focus to compliance assistance that we usually expected to see and did largely see on the MSHA side. And that a great deal of that has to be attributed to the fact that there was never a Trump appointee or nominee confirmed to lead the agency. So, with that, we do have the acting deputy and Jeanette Galanis. So there is some authority from the current administration in place. We saw a bit of that with the March edition of new COVID or updated COVID guidance from MSHA. As we've seen throughout this, MSHA really took a pretty hands-off approach to attempting to regulate or really even engage that directly with COVID policies in mind, and they're still giving operators a lot of latitude to do what they think is best. But what this guidance came out and said is that they recommend that each mine have a COVID protection plan in place. That is to include things like doing a hazard assessment, determining what type of PPE might be required, putting in different types of work practices or even controls to limit the spread. Now, a lot of that is going to be based off the determinations of the individual mine, but that is something that MSHA recommends. There hasn't been a lot of enforcement from MSHA on this front, but an interesting change from the guidance that came out early in 2020 to this guidance in 2021 is that MSHA included in it a list of applicable standards for enforcement. And it's really the ones that we thought were probably going to be the case early in 2020. Workplace exams, safeguards and PPE were necessary, training. These are all kind of the catch-alls, especially workplace exams and training for MSHA. They don't have the general duty clause. They don't have an ETS right now. So those are areas where it's pretty easy for that to come into play. Again, though, for the most part, MSHA isn't grilling companies on it. At least that's been my experience with the companies I've been working with. One other interesting thing that came out of that guidance was MSHA's really discussion of recording and reporting. So previously, under the prior administration, MSHA really, at least formally, did not consider COVID-19 to be work-related unless it was a pretty egregious and pretty definite case of exposure. In terms of what MSHA said here is if it can be determined to be work-related, you would have to submit a 7001 because it would be an occupational illness. They did, though, say that work-relatedness determination is left to the company. So when you're making these decisions, if you're making these determinations, what are you looking for? Is there a reasonable basis outside of the mine that the person could have caught COVID? Were they going to another job? Were they going to parties? Did they go to a concert? Something like that. Or were you having an outbreak at your mine on a particular shift that person is part of? In that instance, it may be a work-related, and then you have to submit your 7001 to MSHA. So that's something to consider, though, because it really wasn't pushed upon a great deal in the prior administration, but coming out in March, MSHA said that they expect it to be reported to them if it is determined to be work-related. And so that not only brings into, question, are you doing the determinations, but also, what is your framework for that? That's going to come down. That could be a training item. So not only if they find out that there's a case that wasn't reported, could you be looking at a Part 50 violation, but you could also be looking at, is there a training issue? And then are they going to go into other concerns there? So an interesting change. The COVID protection plan was a big shift that had previously not been recommended, at least in writing, by the agency. So something to change there. Do they have an emergency temporary standard? No, MSHA does not. OSHA has one that is specific to healthcare right now. And I say that because, who knows what's going to happen as the Delta variant continues to tick up numbers. in terms of cases. I just saw this morning that we're at, as a country, the most confirmed cases in a day since February of this year, when things were quite bad. So, you know, is that going to drive additional action from the regulators? I think they're waiting to see right now how quickly this will dissipate, or if it doesn't at all. But, you know, OSHA went through a rulemaking process on their ATS. It was at being reviewed and having industry input for quite some time. As a result of all of that, they decided not to post an ETS or publish an ETS for all industries, but just for healthcare. MSHA has said on stakeholder calls that they have an ETS drafted. It's ready to be issued if they must issue one. They don't really want to, according to the stakeholder calls. They would rather rely on guidance, but nonetheless, they have one there if they're pushed to do so. I think if OSHA would have issued a ETS for all industries, we might have seen the ETS from MSHA come out. But given that they focus just on healthcare, that gave MSHA the ability to rely on guidance, because that's what OSHA is doing at all other facilities than those that are healthcare related. MSHA claimed that their rule was very targeted and very specific, based off of the discussions that they've had and the guidance they put. It was probably going to be limited to practices for the transportation of people to meeting areas. So hoists, man movers, things like that, where there was a lot of concern about the proximity of individuals. But we don't know for sure because we haven't seen it. So with what's going on right now with the rates, could we see an ETS from MSHA? I think we could. It's always possible if things continue to get worse or don't improve from where they currently stand. But before that happens, I think we're going to have to see OSHA come out and issue an ETS for all under industries. So an interesting change there. We're also going to have to be on the lookout for new guidance from MSHA. They haven't posted anything yet, but just last week, OSHA posted some new guidance for all industries, kind of realigning with where the CDC is now. You should pay attention to that as a mining company, because it's, you know, MSHA throughout this has largely referred and deferred to CDC and OSHA guidance, and that's largely because they weren't putting it out as quickly or as detailed as those other entities. So, you know, if you haven't taken a look at the new OSHA changes, I recommend you do so, just to make sure you can be on top of everything that's happening. MSHA hasn't issued new guidance. I haven't heard that there's any coming, but that doesn't mean they couldn't update what they currently have to incorporate some of that. But again, MSHA's guidance is broad enough that it doesn't get really into specifics, and it tells companies to keep on top of other best practices. And I think that's what you should probably be doing. So pay attention to what the CDC and OSHA are recommending. And if there need to be changes to protect the workforce at the mine, you know, you can certainly do that. MSHA is not outlawing the implementation of other recommendations. So where are we at with enforcement statistics? If you joined me earlier this year at our 2020 look back, looking forward to 2021, we talked a bit about all these stats, and I don't want to spend too much time here just dwelling on numbers, but MSHA has finally updated their MSHA at a glance information to include 2020. And I think that's an informative thing to look at. So if you're looking at the screen right now, we have two charts. The top chart is for all mine safety and health, so coal and metal, non-metal, and the bottom chart is just for metal, non-metal, because I think that's probably the vast majority of you listening today. So we'll focus on those two. If you're going from left to right, the last column is 2020. So, you know, I think it's interesting if we're looking at the top chart, the number of mines, again, stayed relatively stable, lost about 200 and some in 2019 to 2020. If you go down to the metal, non-metal side, you can see that's about 140 or 130 mines. So not a huge drop off given the overall number on the metal, non-metal side. I think though, if you go down and you're looking at the citations and orders issued, that is the pretty stark change. If we're looking at the top table, so all mine safety and health, MSHA issued just under 78,000 citations and orders in 2020. That's 22,000 less than in 2019. And that is nearly more than 40,000 less than they issued in 2014. That is a huge drop off in a 5-year time period. I kept 2014 and 2015 in here because those were the last 2 real earnest years of the Obama administration. We saw we were at 120 citations issued, 20,000 citations issued in 2014 and 107,000 in 2015, down to 77,985 in 2020. So just looking at that data, we did see a pretty big drop, especially in the last year with enforcement. Now, is part of that drop attributed to COVID? I'm sure it is. I'm sure a lot of that has to be with MSHA was doing more abbreviated and more expedited inspections in 2020 for the most part. And I think that probably has something to play in it. It was also election year. We typically see a drop in enforcement in an election year. I mean, look at 2016 for all enforcement compared to 2017. You have a 10,000, really roughly a 10% change there back when the Obama administration was still in power. So that's relatively normal, but going from 100,000 citations in 2019 to 78, that's a pretty big drop off in 1 year. So I think the industry needs to probably be prepared that that's going to uptick. In terms of the S&S citations, as the mining industry overall, it got down to 18% as S&S. As you can see, that is a 6% decrease since the Obama administration. We'll probably see that number ticking back up as well. So there are changes I think that we could prepare for, or at least anticipate are going to happen. If we're looking just at the bottom, just at the metal non-metal operation, we can see that there was also a drop off in citations and orders issued, but it wasn't as steep as when we're looking at all of it, which tells us, the majority of that drop off in enforcement was in coal. Metal non-metal, again, though, they dropped under 20% on the S&S rates for really the first time in quite a long time, if ever. So that is something to watch. I think everyone should be prepared that in the next year or so, we're probably going to see an S&S number start ticking back up again. Overall, from an enforcement perspective, we saw a pretty light year in terms of total penalties, less than 23 million, which again, there was one other year, 18 was around there, but otherwise it's a pretty big drop from the end of the Obama administration to now. So, things to consider as we go through this and we look at all the data. I also, looking at the numbers in terms of fatalities, this is something that MSHA always pays attention to. So we saw last year, 2020, there was 29 mining fatalities for coal and metal non-metal. Of those, 24 were attributed to metal non-metal. This year, and we're just in August, we'll take a look at this, but MSHA has 24 fatalities attributed to the mining industry on their website. So we're getting pretty close to last year's numbers already, and we still have a good bit of the year to go. I think that's going to drive more enforcement, as we'll talk about here in a minute. So looking at that though, what do we see in terms of how or where MSHA might be focusing? You guys have probably heard about it. You've probably received information about it. You might have even received a visit from MSHA to talk about it in the last month. But powered haulage safety is a big focus right now for the agency. They have an initiative that's been in place since 2018. It continues to be. And really, powered haulage is a pretty big category in terms of what it covers. It covers mobile equipment operation, both surface and underground. It covers the use of seatbelts. That's something that MSHA continuously drives home. It includes dump point inspection, dump point maintenance, operations and practices, and not to mention conveyor belts. So there's a lot of areas that are included in there for the purpose of, what might be coming down the pike. MSHA is going to continue on this. They've said that they're going to start enforcing on it, and the data ties it to a lot of the fatalities that have occurred. Additionally, MSHA has a rule in progress. This would be specifically for surface mobile equipment or surface areas of underground mines, but it's going to be a requirement, and we don't know what it exactly looks like yet because we haven't seen the published rule. But a safety program has to be developed and implemented at each operation. And it will be covering things like mobile equipment use, inspections, training, dump point, all those work practices. It is not going to cover or regulate conveyor belts. That's going to be something that's left out of that rulemaking. At least that's what we're hearing at this point from MSHA. But the rule has been drafted, it has been proposed, and it is pending review at the Office of Management and Budget. So we haven't seen that yet. The rule has been there since late April. MSHA also came out and did a safety stand down in the last month on powered haulage safety. So it's going to get a lot of attention. In a recent stakeholder call, Jeanette Galandis said they are going to encourage more enforcement in the area to help curb the rise in fatalities and serious injuries. Another area is going to be whistleblower rights. I think everyone probably predicted this. So discrimination claims, interference claims, and the prosecution of them when we had the Biden administration elected. This was a significant focus of the Obama administration across the board, not just at MSHA, not just at OSHA, not just at the DOL. Across the board, whistleblower protections were focused under that administration. We are likely, I think most people anticipate, we'll see a renewed kind of vigor and a renewed focus on those during the Biden administration. And just recently, just at the end of last month, both MSHA posted about the Whistleblower Appreciation Day, as well as a blog on the DOL website that was authored by Jeanette and Jim Frederick. So the acting heads of OSHA and MSHA put together a blog about whistleblower protections. MSHA tweeted and put notices up on their website about what is included, what are minors' rights, what do you have the right to do, what kind of protections are available. I think that this is going to be an area that we're going to see a lot of resources shifted to and focused. The special investigation units and the special investigators during the Trump administration, I think there was a significant drop-off in the number of cases that they were handling and the number of cases they were pushing and taking up. I think the data supports this, especially on the whistleblower side. I would imagine that this is an area we will see more resources dedicated to and more cases being brought forward. It's important to remember, obviously we never want to discriminate against a minor for initiating their minor's rights, but if you do have a complaint come in for discrimination or interference, those move very quickly and you need to be prepared for that. They are going to get a lot of focus from MSHA. They are going to be prioritized from other kinds of special investigations like agent investigations. The investigators are going to be looking into all of your policies regarding discipline and minors' rights and safety and health programs, and they're going to be looking pretty critically at those. Additionally, with MSHA, you have the ability or that the minor that is claiming discrimination or interference can seek temporary reinstatement, meaning you have to financially make them whole during the pendency of the investigation and the litigation. If that is granted, it's a very low bar. So if you get a 105C claim come in, you need to act quickly. I recommend that you try and work with counsel, whether internal or external, to best position the company for defense of this and hopefully head it off in the investigation timeframe. Because if it gets to the point that MSHA moves forward and takes up the case of this individual, essentially you now have MSHA being counsel for them, and they will take it up and they will litigate it. And it becomes a very time-consuming, a very drawn-out process. So, with anything, just like an MSHA inspection, just a regular one, your best time to challenge it and your best time to succeed is during the investigation. So you need to act quickly, though, and be prepared for that. If you get a complaint, if you get a notice from an MSHA investigator that they are going to be looking into the company for a discrimination or interference claim, you need to mobilize. And you need to mobilize right now so that you and the company can start putting together your defense and also start looking into it yourself and see, what is our exposure here? Is this actually a valid claim? Is it not a valid claim? What do we need to clarify to this investigator to really sort through this? So, that's what we're seeing on the trends and initiatives. Those are areas that are going to get a lot of focus. Additionally, if we're looking at the MSHA website, we're tracking the information that they post and that they track and that they're looking at as well. One of those things is always fatalities, unfortunately, and that's going to really drive forward the trends in their enforcement. We've talked about that with powered haulage already. So on MSHA's website, they note that there are 24 fatalities this year attributed to the industry. Although when you go through and you try and count them down, they only have 23 listed in that area of the website. So a little bit of a departure there, but looking at the 23 they have listed, 16 of them are metal, non-metal, and 7 are coal. So if we, saw the data from last year, metal, non-metal had 24 fatalities and coal had 5. Coal's already exceeding that. Metal, non-metal is not there yet, and hopefully we don't get to that. But right now, it's really a fairly decent year on that sense. If we were to finish the year at 16, that would be fantastic. That would be a very good year. Obviously, the goal is always 0, but that would be a relatively low year from recent history. But we aren't at the end of the year, we're in August. So companies need to, take note of this kind of uptick. MSHA has taken note of it. We need to all be dedicating or rededicating ourselves and our workforces to safe practices and, compliant practices, but also be aware that these are areas that MSHA is going to be looking for citations, because these are areas that they have a trend with serious injuries or fatalities. So obviously, the biggest one is powered haulage. That's why there's the initiative. That's why there's a rulemaking, and that's why we had a safety stand-down day sponsored by MSHA that focused exactly on that. And that's going to be mobile equipment operation, vehicle crashes, dump points where trucks or other equipment go over the edge. It's going to also include lockout, tagout, and guarding on conveyors and other types of work practices, crossing conveyors. If we have those practices going on, we obviously need to stop them. We should consider retraining everyone on our company policies and our safe practices in that area. And if we do any retraining or do any safety stand downs or any kind of toolbox talks on them, make record of it. Take credit for what you're doing and the good practices that you're trying to reinforce. Also, this is something that we don't have the luxury of, this affirmative defense with MSHA, but in the world of OSHA, there's a defense called unforeseeable, unpreventable employee misconduct. And essentially, if a company can prove that they trained the employees to always do something, they trained them that this was a proper way to do it. And I'll just say something as simple as, when you get down to the end of this hallway, turn left. This is why you turn left, because it's dangerous to turn right. So you enforce people and discipline people with your discipline program who turned right when they should have turned left. If you go through all these steps and you have the training in place, you have records of the training, you have policies and procedures in place about it that they have been trained on, you've enforced that training. If someone goes down there and they turn right when they should have turned left and they get injured, you can assert unforeseeable or unpreventable employee misconduct, and that can be a bar to the citation, a defense to the citation at issue. MSHA doesn't have that because MSHA is a strict liability statute, but that is still very important documentation and a policy or procedure to go through and to document, so that you can make the argument that the company did everything it could to train and teach and enforce their safety and health policies. And that goes directly to company and agent negligence if MSHA is doing an investigation and trying to look at enforcement. So if you are doing training, if you're doing retraining, I encourage you to do so, but make sure you document everything. If you have company policies in place on seatbelts, for example, make sure you're enforcing it. You know, if you have a program that says we're going to give a verbal, then we're going to have a written notice, actually follow that and follow it uniformly for every employee, regardless if they've been there for 3 decades or 2 weeks, or that's your best friend, or that's someone that you don't get along with that well personally. Enforce it uniformly, make record of it, keep those, and that will help you if there's ever an incident to really build the case that you as a company were doing what you could to train, enforce training, and keep the mine site safe. And perhaps it was someone acting in violation of that. So, you know, falling material is another area that we see a number of site fatalities this year. And I have seen an increase in the amount of citations for ground control, especially high walls, working around high walls in underground mines. They're looking very closely at roof construction and stability, so be aware of that. Machinery is just kind of a very broad category. A lot of that's going to come back to guarding. So make sure your guarding is there, make sure your guarding's in place, make sure it remains in place, and make sure if there's any repairs where it's removed, those are replaced at the end of it. The other ones, you know, you have a couple on slip and fall and material handling and one in inundation, but I think the first 3 are really where you're going to see MSHA paying a lot more attention. You know, housekeeping is always an issue, and that can really apply to slip and falls, and that's something that's always low-hanging fruit for the agency. So make sure you're watching out for those standards as well, but really pay attention to your powered haulage, your safety programs on the operation of mobile equipment, your operations and maintenance programs for conveyor belts. Those are going to be areas that MSHA is scrutinizing. So as we, you know, round up on what's going on with MSHA and where we think they'll play their focus as the year goes out, what's happening with the Federal Mine Safety and Health Review Commission. So for those of you who know, the commission is an independent agency that hears our challenges or our litigation with MSHA before we have the ability to take it to the federal court system. It's made up of a commission panel of 5 individuals or up to 5 individuals. They also have administrative law judges who work for them. So the way it really works is if you challenge a citation or you challenge that penalty document that comes in the mail, you're challenging something before the commission. You go to an ALJ. If you aren't able to settle it and you go to a hearing and you want to appeal that, you appeal it to the commission. If you don't like the commission decision, then you have the ability to appeal to the federal circuit court system, all the way up to the Supreme Court if you so desire. But the commission is really where the vast majority of the cases live and die in terms of their litigation life cycle. So right now, of the 5 seats available on the Federal Mine Safety and Health Review Commission, 3 are filled. The chairperson is Arthur Traynor. He served on the commission since March of 19. He is, you would call a labor side selection. He has experience working in-house with the United Mine Workers prior to starting his own law firm for a bit and then getting selected to the commission by President Trump. His term expires in August 2022. So he's got another year before he either needs to be nominated again for the position or replacement put in. There's 2 other commissioners in place as well, and all 3 of these individuals were either nominated and confirmed or reconfirmed in March of 19. So Marko Rikovic, he has served on the commission since 19. He was the chairman from 19 to 21 until Chairman Traynor took over. His term, along with that of Commissioner Alphen, ends on August 30th, 2024. So we have a couple more years with Commissioners Rikovic and Alphen, both of whom, prior to being on the commission, were industry side defense attorneys, similar to myself. So right now, from an industry perspective, it's a favorable bench for appeals. That is a good thing. There are 2 open seats, so President Biden, it's probably not high on his list at the moment, but he could submit 2 additional nominees. And if those are confirmed, they would likely be labor side, and it would give the commission a 3-2 majority on the labor side versus the industry side. That's typically what we would expect. Additionally, with Chairman Trainer's term expiring in 2022, he'll be able to be renominated or his position filled. So what that really puts us at is, for the time being, industry has the majority, or at least industry leaning commissioners are the majority, but that could very quickly change. So right now, though, it's more favorable to appeal to the commission. Commissioner Alton has served on the commission in one way or another largely since 2013, so he's pretty experienced on there. All of them, though, are experienced in mine safety and health law. So where are we at with the state of proceedings? The commission and its ALJs have really stepped back, as we've seen most companies, both private and from the federal government entities do. They are not holding in-person meetings or mediations or status conferences or hearings. They have the ability to do so, but they are strongly encouraged not to by the chief ALJ. This was again extended to the end of the year of 21, just earlier this month. I strongly encouraged or discouraged from setting in-person meetings. It essentially means they aren't. All the ALJs that we've been dealing with are largely setting everything to be virtual. So hearings by Zoom, mediations by Zoom, settlements by Zoom, settlement conferences by Zoom if you need to do so. And that's also largely the focus of the federal government right now too. There's some reluctance by the solicitor's office to engage in in-person meetings and by those Pearsons at MSHA. So for the time being, we're going to continue down this virtual route. I will say, at a conference back earlier in March, when it seemed like things might be going in a more positive direction and we might be moving out of this over the summer, as we did for a bit, the chief ALJ discussed that even after or post-COVID, the ALJs were likely to keep doing virtual hearings. They thought that was an effective tool. I can tell you, from my position, I'm not a fan of virtual hearings. I don't think many of the other judges are, or our colleagues over at the Secretary's office representing MSHA, but that is something that at least the chief judge seems to be a fan of. Also, if you are working on any contests of your own, if you're doing a pro se or you're working with counsel, these are all going to be going electronically with the commission docket office right now. So if you're having issues with that, or you're having issues with mail or faxes that you've sent previously getting in, you need to start doing that electronically. If you want to talk about that with me, I'm happy to work with you on it and get you set up on that sense. But you need to make sure you don't want to be losing out on your contest or missing deadlines because you're filing things with snail mail, which is disturbingly unreliable at this point in time, or fax, where the docket office is operating virtually, and so they're really not checking that very often. So beware of that. You're not going to get much in the mail. This is all going to be email, so make sure you give them a good email when you're doing that. So what are we seeing in trends? One thing we're seeing, there has not been a lot of litigation given where we're at with the pandemic. I think a lot of people have been trying to push off hearings as long as possible to try and get those in person. So we're probably going to see that coming to a head here soon, because we can't, delay litigation forever. But one thing that has been a positive during the pandemic is that the commissioners are moving through motions to reopen very quickly. They're clearing the backlog, which was very deep. I mean, it took at least 12 to 18 months to get a motion to reopen ruled upon, and you file these when you miss your 30-day deadline from the date the penalties are received. So if you miss that, you have to file a motion to reopen if you want to contest anything. And that's your right to do so, but it was a very long time before those came back around and were either approved or that motion was not approved. What we're seeing is that this commission panel is moving very quickly on these, which is a good thing. They're clearing the backlog and they're moving quickly on the new ones that come in. That's a positive. You have to file those directly with the commission. You need to really file them within 30 days of missing your deadline if you can. But that is something that you have the option to. So if you send that form in on the 30th day or the 40th day and MSHA says you can't contest these, this would be your area of recourse. The vast majority of what we see coming out in terms of ALJ decisions and even on the commission side are those decisions related to discrimination and interference complaints. A lot of those coming through. That's one thing, that probably isn't going to change. A lot of them have to do, with temporary reinstatement, which, you have to litigate that, and the claim is made at the very beginning of the inspection or the investigation process, or when it's taken up by the solicitor's office. So there's a number of those decisions out there. We still don't have a hard and fast test that we must use or the judges must use on interference. We're still waiting for that. There's still some cases out there undecided. But and that's an area where we continue to see a lot of focus in terms of litigation. One case that was decided relatively recently by the commission was the second go around of a solar sources. It was an interesting decision in that it was a company who was largely appealing how the judge was determining the penalty. So when a judge is determining a penalty, they need to consider those 6 criteria listed in yellow or orange. That is from Section 110I of the Mine Act. And in that case, they had a judge who only really, they said didn't look at enough of them. And then in the second go around, really only paid attention to 2 of them. And so the company kept appealing it. And recently this month, the ALJ's decision on the most recent penalty was vacated, and the commission just set a penalty itself. So an interesting challenge here as the company continued to really push back on the judge's determination of what was a fair penalty for the violation. And in that case, it was an instance where a haul truck had gone over a dump point. And a penalty, the judge assessed a penalty of $69,000 for it. And the commission on their second go around just this month assessed a penalty of $40,000. So the question was whether or not the judge appropriately applied all 6 criteria. So just a different area where you may not even be litigating on the determination of whether a citation is valid or not valid, but you're arguing the appropriateness of the penalty. And rarely, it's not entirely common that you see penalties high enough to warrant that, but in this case it was. This is a relatively older development, workplace exam, but the change would be that there was litigation going on regarding the workplace exam rule. There was a couple different sets of litigation going on here too. Really, the interesting part is that the first one came in 2017 when MSHA published their final rule for the new workplace exam, and an industry challenge went to that in March of 2017 in the 11th Circuit. That decision or that case had been stayed for quite some time, given the changes to the rule and that it was modified, and then there was this litigation regarding the 2018 rule in the DC Circuit, and just in January of 21, another petition for reviewing the legality of the rule overall by that industry groups was denied in the 11th Circuit. So pretty much means we're stuck with what we have in the 18 rule. If you may recall that there was that 2018 rule where it allowed, and I have the different provisions, but MSHA made some changes to the workplace exam rule. They said that the workplace exam had to be done at least once each shift before work begins or as miners begin work in that place. That was the change, the addition of or as minors begin work in that place. And the second change was when a condition that may adversely affect safety or health is not corrected promptly, it shall be included on the record. So that was saying that if you corrected a condition while you were doing your inspection or very shortly thereafter, promptly, and this rule means before minors are exposed, you did not have to include it on your workplace exam as an adverse condition, and then you didn't have to track the corrective date. I liken this a lot of times to if you're doing a workplace exam and you're walking along a catwalk and you come upon a hose that is just either coiled or not coiled and laying in the middle of it. That's technically a slip trip hazard and an adverse condition. And if you just picked it up and hung it up, under the 2018 rule, you weren't obligated by MSHA to write on your workplace exam that there was a hose that you picked up. And when you did that, the labor unions challenged that, saying that MSHA's rules did not further safety and health. They offered actually less protection than the final 2017 version. And the DC Circuit agreed with that and reverted back the rule to the 2017 edition. So what that means is right now, this is the version of the rule that we should all know that we're following and we should all be following. So workplace exams, you don't get that clause that you can complete it or as they begin work in a place. It has to be done before minors begin work in an area. Additionally, you have to record, according to MSHA and according to the regulation, any adverse conditions that you find, and then on that record, and also the date of the corrective action. So, keep on top of this. We haven't seen a lot of enforcement on the new workplace exam record since it came out, and I think that's because it's been in constant flux. This has been the case for a while now, and I'm starting to see an uptick in the amount of citations being issued. I've also seen MSHA's kind of going back to a trend, which we saw really a lot more at the end of the Obama administration. And I saw this not just since the last election, but even at the end of 16, or the end of 20. The inspectors are writing workplace exam citations if they find a high number of similar hazards. So say you have a lot of, the MSHA writes 4 citations for housekeeping. I'm starting to see more citations that now say, here's a citation for not doing your workplace exams well enough. So watch out for those. Those are sometimes issued as high negligence. There's often SNS. You should be doing training for anyone performing a workplace exam or tasked with completing it on how to do that and what they should be looking for. Make sure that you document all that task training and you don't just say, hey, it's part of their on-the-job training, because that will help you in defending against those kinds of citations and allegations. Also, if you do have a lot of different individuals doing workplace exams at your facility, because I know that varies widely now with this before the minors enter a place requirement, are you auditing that? Are you checking up on the work they're doing and trying to make sure that your minors are doing good workplace exams, that they're actually, observing conditions and noting them, or are they just going down and checking a bunch of boxes that everything's okay? Those are things that we want to look at and audit too, because that's what MSHA is going to look at if they come out and they see what they think is maybe a systemic issue before they start issuing a citation under workplace exams. So that's an area that we want to take a look at. It looks like there is a question came in: how long do workplace exams need to be kept available to MSHA? The rule requires that you maintain records on site for workplace exams for 1 year, 12 months from the date they're completed. So, if you do one today, you can get rid of it on August 20th, 2022. That would be how long you need to maintain those, and you need to be able to make those available to MSHA upon request. If you are maintaining records, longer than that, I would encourage you to revisit why you are doing that and why you're retaining those more than a year. If MSHA becomes aware of that, if there's an accident investigation or something along those lines, they can request them, and it's pretty hard to fight that if they want documents that you have and they know you have that are workplace exams for more than 12 months. So I would encourage you to evaluate whether or not you want to keep them that long. But no, you need to keep that record for 12 months and provide it to MSHA upon request. All right, everyone, I think that's pretty close to time, about an hour on the dot since we started. As always, feel free to subscribe to or follow the MSHA Defense Report. Check that out for any additional changes that we see or any other updates that we think are relevant to the industry. Additionally, we have the rest of the webinar program. Our next one is highlighted there, so it's going to be next month on the 14th. It's going to be a discussion of MSHA and OSHA jurisdiction, where those lines lie, and when and how you might want to be challenging that if you're either starting a new operation or have any questions about that at your site. As always, my contact information is up on the screen. I welcome and encourage you all to reach out to me directly, whether by phone or email, if you have any questions, you want to talk anything through. So thanks everyone for joining me today and listening, and hope that everyone has a safe rest of the week and safe rest of the year, and we'll talk to you again in a month.